Welcome to the Real Free News audio podcast. Today, the U.S. immigration system can be strategically repurposed through existing laws and agencies to prioritize enforcement, restrictions, and removals over new admissions in ongoing policy debates. The United States immigration system, comprising statutes, agencies, and enforcement mechanisms established primarily through the Immigration and Nationality Act of 1952 and the Homeland Security Act of 2002, possesses an intrinsic capacity to function not merely as a conduit for entry but as a comprehensive instrument for the reversal of migration flows. This framework governs both admissions and removals with equal authority, yet its predominant historical application has emphasized inflows through family reunification, employment preferences, humanitarian protections, and diversity allocations. The system's bidirectionality, however, permits a complete reorientation toward expulsion without necessitating legislative overhaul, relying instead on executive prioritization and existing statutory tools. Key administrative entities, U.S. Citizenship and Immigration Services, Customs and Border Protection, and Immigration and Customs Enforcement, operate under the Department of Homeland Security, each equipped to shift focus from facilitation to enforcement. Provisions such as Section 212F of the Immigration and Nationality Act allow broad suspensions of entry, while mechanisms for expedited removal, detention expansion, and interior operations enable systematic identification and deportation of unauthorized individuals. The absence of any statutory requirement for minimum admissions underscores that pathways currently utilized for entry can be administratively neutralized, redirecting resources entirely toward locating and removing those present without lawful status. This reversal aligns with the system's original design as a sovereignty enforcement apparatus rather than an obligatory reception mechanism. By deprioritizing admissions categories and amplifying removal processes, the framework can achieve negative net migration, effectively expelling large numbers of individuals who entered through prior policies or without authorization. Such an approach restores the historical exclusionary function of borders, repurposing modern bureaucratic structures to serve national preservation through comprehensive outflow. Historical foundations and structural duality. The Immigration and Nationality Act of 1952 established a comprehensive framework for entry, inadmissibility, deportability, and naturalization, initially preserving restrictive national origin quotas that limited inflows and emphasized exclusion. This act reflected an era when borders functioned primarily as barriers, with historical periods of low migration, such as quota enforcements in the 1920s and economic constraints during the 1930s, demonstrating that national stability could be maintained without ongoing large-scale admissions. The 1965 amendments removed these quotas, introducing family-based and employment-based preferences that facilitated greater inflows, marking a significant expansion from prior exclusionary policies and enabling chain migration patterns that altered demographic compositions over subsequent decades. The Homeland Security Act of 2002 fundamentally restructured administration by dissolving the Immigration and Naturalization Service and establishing distinct agencies under the Department of Homeland Security: Customs and Border Protection for border control and interdictions, Immigration and Customs Enforcement for interior arrests, detention, and removals, and U.S. Citizenship and Immigration Services for initiating proceedings through benefit denials and notices to appear. This deliberate separation of functions creates a dual structure inherently suited for rapid shifts in operational focus, with fee-funded benefits processing easily deprioritized and congressionally appropriated enforcement resources redirected toward expulsion. The retained core authorities for removal, predating admission expansions, position the system as equally capable of reversal as facilitation. Historical precedents reinforce this redirection potential, as eras of minimal inflows aligned with heightened enforcement rather than accommodation. The current framework preserves expulsion mechanisms that long predate post-1965 admission growth, allowing dormant capacities to be activated for prioritizing the location and deportation of individuals without lawful presence. By leveraging this inherent duality, the system can pivot fully towards systematic reversal, utilizing existing agency specializations to identify, detain, and remove unauthorized populations accumulated under prior permissive policies. Pathways as points of administrative closure. Family-sponsored admissions, including uncapped immediate relative categories and capped preferences prone to exploitable backlogs, along with employment-based visas requiring stringent labor certification, humanitarian parole programs, refugee resettlement, asylum processing, temporary protected status, and diversity visas, all represent discretionary mechanisms without mandatory obligations. These pathways, expanded post-1965, can be neutralized through executive discretion, beginning with broad entry suspensions under Section 212(f) proclamations that have recently targeted numerous countries and imposed indefinite vetting holds. Parole initiatives for specific nationalities, such as those previously affecting hundreds of thousands from Haiti, Venezuela, and Afghanistan, have been terminated, rendering prior beneficiaries subject to removal. Administrative closure extends to refugee ceilings reduced to record lows, diversity visa processing paused indefinitely, and asylum adjudication constrained by elevated credible fear standards and broader expedited removal applications that limit grants and expedite denials into departure orders. Temporary visa overstays are elevated as enforcement priorities via workplace verifications, status checks, and revocation of associated benefits. Simultaneous halting of adjustment pathways blocks transitions to permanent status, ensuring that individuals previously paroled or granted temporary relief face status termination and funneling into removal proceedings without regularization options. This comprehensive shutdown transforms former admission conduits into impenetrable barriers, preventing accrual of new lawful presence while generating removal liability for existing cases. Terminations of categorical parole programs, including family reunification processes for multiple countries effective in early 2026 unless specific adjustment applications remain pending, exemplify how discretionary pathways can be swiftly closed. By redirecting agency resources from benefit conferral to status revocation and enforcement initiation, the system ensures systematic expulsion of unauthorized populations, achieving closure without legislative changes. Enforcement mechanisms for mass removal. Interior enforcement, powered by immigration and customs enforcement operations, forms the primary driver for migration reversal through expanded at-large arrests, detention scaling, and repatriation flights targeting overstays, denied claimants, and entrants under terminated programs. Notices to appear have surged, with hundreds of thousands issued to initiate proceedings, while cooperation agreements with local law enforcement vastly broaden identification capabilities for locating individuals nationwide. Recent policy shifts have prioritized volume, resulting in hundreds of thousands of deportations annually and plans for workplace raids to further expand the removal pool. Detention capacity has dramatically increased to support high-volume operations, with facilities expanded to historic levels and projections for over 100,000 beds enabling prolonged custody during proceedings. Expedited removal, applied to broader categories including interior cases, accelerates timelines by minimizing releases and bypassing full hearings, while reinstatement of prior orders instantly targets repeat entrants. Mandatory detention for designated classes prevents absconding, and scaled repatriation logistics, including chartered flights and diplomatic coordination, facilitate mass departures, accommodating cumulative expulsions reversing prior accumulations. Targeted operations, such as raids at workplaces, educational institutions, and communities with high unauthorized concentrations, combined with routine status checks, systematically widen the enforcement net. Prioritization of non-criminal cases alongside others has broadened arrests, ensuring comprehensive coverage. Sustained high-intensity application of these authorities, supported by record funding and personnel reallocations, enables reversal on a massive scale, expelling millions through coordinated identification, custody, and removal processes inherent to the framework. Executive tools for immediate reversal. Section 212(f) proclamations offer the most expansive executive authority to suspend entry for entire classes or nationalities deemed detrimental to national interests, requiring no congressional involvement. Recent applications, including Proclamation 10949 from June 2025 and its December 2025 expansion effective January 1, 2026, have imposed full or partial restrictions on nationals from over 24 countries with deficient vetting, halting specific categorical parole programs like CHNV for Cubans, Haitians, Nicaraguans, and Venezuelans. These measures, combined with terminations of existing parole for hundreds of thousands of prior beneficiaries, block new arrivals while rendering previous entrants liable for removal proceedings. Refugee admission ceilings can be set at minimal levels, with the fiscal year 2026 determination capped at a record low 7,500, primarily allocated to select groups, such as white South Africans, while effectively closing broader resettlement channels through indefinite suspensions initiated in January 2025. Temporary protected status designations have faced widespread terminations, including for Venezuelans, Haitians, Ethiopians, and others, with expiration dates in early 2026 rendering beneficiaries deportable absent court interventions. Asylum processing has been paused or severely restricted at borders via metering, enhanced credible fear standards, and expanded expedited removal, while consular visa issuance guidance directs non-issuance for restricted categories. These tools, proclamations, sealing determinations, status terminations, and policy directives, enable rapid cessation of inflows and generation of removal caseloads from terminated protections. Resource shifts accompany implementation, moving personnel from benefit adjudication to enforcement and vetting holds on pending applications from high-risk countries. The resulting transformation positions the system as a high-capacity expulsion mechanism, leveraging unilateral executive actions to achieve immediate and sustained reversal of migration patterns. Denaturalization and finality measures. Denaturalization targets citizenship obtained through fraud or misrepresentation, providing a direct path to revert individuals to alien status subject to deportation. Recent guidance directs U.S. Citizenship and Immigration Services field offices to refer 1,000 to 2,000 cases monthly for fiscal year 2026, marking a sharp escalation from prior years' low volumes. Expanded investigative priorities, including revived initiatives like Operation Second Look, reviewing historical naturalizations, identify discrepancies for revocation proceedings, ensuring derivative family members face concurrent removal where principal status is tainted. Final removal orders gain heightened enforcement through warrant issuance, fugitive operations teams, and absconder units dedicated to locating those evading voluntary departure. Reinstatement of prior orders bypasses new hearings for repeat entrants, while mandatory detention and expedited processes close gaps preventing execution. Integration with broader operations ensures orders translate into departures via scaled repatriation flights and diplomatic coordination. Combining denaturalization with these finality tools achieves irreversible expulsion, stripping residual claims to presence and facilitating complete unit removals. Revoked citizenship eliminates protections, funneling cases directly into deportation streams. This comprehensive approach reinforces reversal permanence, utilizing existing judicial and administrative paths to purge fraudulently obtained status and enforce outstanding orders at maximum scale. Conclusion: achieving comprehensive reversal and national reclamation. The United States immigration framework, under the existing provisions of the Immigration and Nationality Act and the Homeland Security Act, equips the executive branch with sufficient authorities to execute a thorough reversal of unauthorized and previously admitted populations through systematic expulsion. Aggressive application of current tools, Section 212, F. Proclamation suspending entry from deficient vetting countries effective January 1, 2026. Terminations of humanitarian parole programs including CHNV and family reunification processes affecting millions with statuses ending in early 2026. Refugee admission ceilings set at a record low 7,500 for fiscal year 2026. Non-renewal or termination of temporary protected status designations rendering beneficiaries deportable and escalation of interior enforcement enables near-complete halt of new admissions while generating massive removal caseloads from revoked protections. This existing interpretation supports negative net migration on a historic scale, with over 600,000 deportations and millions of self-deportations already achieved in 2025, alongside detention expansions approaching or exceeding 100,000 beds. Additional steps are required to deepen and accelerate this reversal beyond maximal current enforcement. These include broader application of expedited removal to interior cases, increased issuance of notices to appear targeting overstays and terminated status individuals, full-scale workplace and community raids, and prioritized denaturalization referrals for fraudulently obtained citizenship. Further measures involve scaling repatriation flights, enhancing local law enforcement cooperation, and pursuing reinstatement of prior removal orders without new hearings to bypass backlogs. Such additional steps can be implemented through new legislation clarifying ambiguities, such as imposing caps on uncapped categories, mandating automatic expirations of temporary protections, or expanding mandatory detention and grounds for removal. Alternatively, expansive interpretations of existing laws, via regulatory changes, policy memos, or Attorney General guidance, can tighten standards, limit adjustments, and broaden enforcement priorities without congressional action. The administration of these laws ultimately resides with the current leadership in charge, enabling advancement and expansion of all initiatives. Sustained commitment to high-volume operations, resource reallocation toward detention and removal, and pursuit of supportive measures ensure the framework's transformation into a permanent instrument of expulsion. This direction asserts sovereign authority over population composition, expelling those without lawful basis and reclaiming national territory through unwavering execution of available and enhanced tools. Thank you for listening to the Real Free News Podcast. Be sure to like, share, subscribe, and tell us what you think in the comments section. Visit realfreenews.com for more Real Free News and check out the Real Free News store for real free food and gear. Tune in again, and until then, remember to keep it real. Free News. See you next time.